Welcome to my channel. This is Bruce the Boss, and another major constitutional court victory this past week as it pertains to the jab mandate, as the Fifth Circuit Court of Appeals just yesterday, Friday afternoon, November the 12th, 2021, just upheld their initial stay of the jab mandate, deeming it unconstitutional. By the way, please don't forget to subscribe to my channel. Your subscriptions will help go a long way with allowing me to produce more content and getting the message out there that is much needed for the people to hear. Because what I am seeing massively is a lot of individuals who are not as informed about what's going on being pressured and intimidated by their employers, who in turn also likelihood does not really know the intricacies of what's going on, and like pawns on the chessboard are just moving based upon what they're told. They're pressuring people to get this jab despite the constitutional questions and their challenges that it's currently facing. And I think the goal of the Biden administration and OSHA, knowing that this would not hold up in court, is to scare people into thinking, okay, there's a January 4th deadline. They have to get it. The clock is ticking. And by the time that this gets resolved in court, majority of the people who they wanted to get the jab will have already gotten the jab. So too late, they've already got it, despite the fact that the courts will likely strike this down, I believe. So what I'm going to do is I will be reading from the law, from the court ruling itself momentarily again, but please don't forget to subscribe to this channel. Your subscriptions, your interactions on this channel, both liking the video and also commenting on this video, will allow it to be spread amongst YouTube even more so, as well as allowing me to keep producing new content to get the message out there. We need to make sure that people have all of the information needed before they make a decision, because it really does not matter what decision you land on. The decision is and should be yours personally, and I will support that no matter what the decision is to be. But we should make sure that people have all of the information available so that they are not forced or pressured into making a decision that they otherwise might not have made, or make a rush decision. So without further ado, let me go ahead and read the court rulings. Let's roll. So the United States Court of Appeal for the Fifth Circuit, case number 21-60845, goes as follows in the near unanimous decision. So they're admitting, right, and from the opening paragraph, that even OSHA determined reasonably back in June of 2020, keep in mind that's the start of the pandemic, that an emergency temporary standard, also known as an ETS, was not necessary to protect working people from occupational exposure to infectious disease, including COVID-19, end quote. This was not the first time that OSHA had done this, though. It has refused several times in the past to issue ETSs, despite legal action urging it to do so. Now, in fact, in its 50-year history, OSHA has issued only 10 ETSs, and this is why I'm very confident that this will be struck down, because only 6 were challenged in court out of the 10, and only 1 survived. Only 1. They're practically batting 0. Out of the 6 challenges, whenever it's been challenged, 1 out of 6 survived. The case concerns OSHA's most recent ETS, the agency's November 5th, 2021 ETS, or mandate, the mandate requiring employees of covered employers to undergo COVID-19 vaccination or submit to weekly testing of COVID-19 and wear a mask. An array of petitioners sought a stay, barring OSHA from enforcing the mandate during the pendency of judicial review. On November the 6th, 2021, we, the Fifth Circuit Court of Appeals, agreed to stay the mandate pending briefing and expedited judicial review. Having conducted the expedited review, we reaffirm our initial stay. OSHA promulgated its much anticipated vaccine mandate on November 5th, 2021. Framed as an ETS, the mandate requires all employees of 100 or more to develop, implement, and enforce a mandatory COVID-19 vaccination policy, and require any worker who remains unvaccinated to undergo weekly COVID-19 testing and wear a face covering at work in lieu of vaccination, end quote. On the afternoon of the mandate's publication, a diverse group of petitioners, including covered employers — I wish it was my company, oh wow, they don't care that much about its employees as much as they promote diversity — states, religious groups, and individual citizens, moved to stay the permanently enjoined the mandate in federal courts of appeals across the nation, finding, and I quote, cause to believe there are grave statutory and constitutional issues with the mandate. We intervened and imposed a temporary stay on OSHA's enforcement of the mandate for ease of judicial review, and in light of the pressing need to act immediately, we consolidated our court's petitions under the case number captioned above. So we begin by stating the obvious. OSHA, which the Occupational Safety and Health Act, which created OSHA, was enacted by Congress to assure Americans safe and healthful working conditions and to preserve our human resources, end quote. But on the dubious assumption that the mandate does pass constitutional muster, we must need to decide today it is nonetheless fatally flawed on its own terms. Indeed, the mandate strain prescriptions combined make it the rare government pronouncement that is both over-inclusive, applying to employers and employees in virtually all industries and workplaces in America, with little attempt to account for the obvious differences between the risk facing, say, a security guard on a lonely night shift and a meat packer working shoulder to shoulder in a cramped warehouse, and under-inclusive, purporting to save employees with 99 or more coworkers from grave danger in the workplace while making no such attempt to shield employees with 98 or fewer coworkers from the very same threat. The mandate stated in its a purported emergency that the entire globe has now endured for nearly 2 years. After the president, so they're pretty much acknowledging that President Biden voices displeasure with the country's vaccination rate back in September, and the administration pored over the U.S. code in search of authority or a workaround for imposing a national vaccine mandate. So this was basically not for the protection of, or they're acknowledging here, this was not for the protection of the American people and employees, but rather just frustration that not enough American citizens had complied with vaccination. But the mandate at issue here is anything but delicate exercise of this extraordinary power. A natural first step in enacting a lawful ETS is to show that employees covered under the ETS are in fact exposed to dangerous substances, agents, or hazards at issue. Here, COVID-19, as it pertains to the vast majority of private employees covered under the mandate, however, OSHA fails to meet this threshold burden. In defending the mandate before the court, the government credits OSHA with describing a myriad studies showing workplace COVID-19 clusters and outbreaks and other significant evidence of workplace transmission and exposure. Of course, OSHA cannot possibly show that every workplace covered under the mandate currently has COVID-19 positive employees, or that every industry covered under the mandate has or will have outbreaks. As discussed below, this kind of overbreath plagues the mandate generally. Equally problematic, however, is that it remains unclear that COVID-19, however tragic and devastating the pandemic has been, poses any kind of grave danger. As important, however, the status of the spread of the virus has varied since the president's announcement, the general parameters of the mandate in September. And of course, this all assumes that COVID-19 poses any significant danger to workers to begin with, that the more than 78% of Americans aged 12 and older, either fully or partially inoculated against it, the virus poses, the administration assures us little risk at all. We next consider the necessity of the mandate. The mandate is staggeringly overbroad, applying to 2 out of 3 private sector employees in America in workplaces as diverse as the country itself. The mandate fails to consider what is perhaps the most salient fact of all. The ongoing threat of COVID-19 is more dangerous to some employees than to other employees. All else equal, a 28-year-old truck driver spending the bulk of his workday in the solitude of his own cab is simply less vulnerable to COVID-19 than a 62-year-old prison janitor. Likewise, a naturally immune unvaccinated worker is presumably at less risk than an unvaccinated worker who has never had the virus. The list goes on, but one constant remains. The mandate fails almost completely to address or even respond to much of this reality and common sense. Moreover, earlier in the pandemic, the agency recognized the practical impossibility of tailoring an effective ETS in response to COVID-19. At the same time, the mandate is also under-inclusive. The most vulnerable worker in America draws no protection from the mandate if his company has 99 workers or fewer. The reason why? Because as even OSHA admits, companies with 100 or more employers will be better able to administer and sustain the mandate. So in other words, this is such a grave risk to the workplace and all, and yet you're only putting this on employers with 100 or more employees. But what about those who work in the same kind of conditions who have fewer than 100 employees, and yet their physical conditioning and or age makes them equally at the same risk? That may be true, but this kind of thinking belies the premise that any of this is truly an emergency. Indeed, under-inclusiveness of this sort is often regarded as a telltale sign that the government's interest in enacting a liberty-restraining pronouncement is not, in fact, compelling. So again, basically saying, if this is such an emergency, why did you limit it based upon the number of employees a company has, not the actual risk itself? It lastly bears noting that the mandate raises serious constitutional concerns that either make it more likely that the petitioners will succeed on the merits or at least counsel against adopting OSHA's broad-reaching as a statutory interpretation. First, the mandate likely exceeds the federal government's authority under the Commerce Clause because it regulates non-economic inactivity that falls squarely within the state's police power. A person's choice to remain unvaccinated and forego regular testing is non-economic inactivity. See the court cases listed here or cited here. And to mandate that a person receive a vaccine or undergo testing falls squarely within the state's power. See Zuck versus King. And it is within the police power of the state to provide for compulsory vaccination. See Jacobson v. Massachusetts. So a lot of people have been referring to this Supreme Court case in particular, but they fail to realize that that was specifically referring to the state, not the federal government. The mandate, however, commandeers U.S. employers to compel millions of employees to receive a COVID vaccine or bear the burden of weekly testing. The Commerce Clause power may be expansive, but it does not grant Congress the power to regulate non-economic inactivity traditionally within the state's police power. People, for the reasons of their own, often fail to do things that would be good for them or good for the society. Those failures, joined with the similar failures of others, can readily have a substantial effect on interstate commerce under the government's logic that authorizes Congress to use its commerce power to compel citizens to act as the government would have them act. But the federal government, by contrast, has no such authority. Indeed, the courts always have rejected readings of the Commerce Clause that would permit Congress to exercise a police power. United States v. Lopez, 517. In sum, the mandate would far exceed current constitutional authority. Second, concerns over separation of power principles cast doubt over the mandate's assertion of virtually unlimited power to control individual conduct under the guise of a workplace regulation. As Judge Duncan points out, the major questions doctrine confirms that the mandate exceeds the bounds of OSHA's statutory authority. Congress must speak clearly if it wishes to assign an agency decision of vast economic and political significance. The mandate derives its authority from an old statute employed in a novel manner, imposes nearly $3 billion in compliance costs, involves broad medical considerations that lie outside of OSHA's core competencies, and purports to definitively resolve one of today's most hotly debated political issues. So at the very least, even if the statutory language were susceptible to OSHA's broad reading, which it is not, these serious constitutional concerns would counsel this court's rejection of that reading, Jennings v. Rodriguez. Accordingly, the petitioner's challenge to the mandate show a great likelihood of success on the merits, and this fact weighs critically in favor of the stay. It is clear that a denial of the petitioner's proposed stay would do them irreparable harm. For one, the mandate threatens substantially burdens the liberty interests of reluctant individual recipients put to a choice between their jobs and their jab. I like how that's now becoming a verb and or an official term. For the individual petitioners, the loss of constitutional freedom for even minimal periods of time unquestionably constitutes irreparable injury. See Elrod v. Burris. Likewise, the company seeking a stay in the case will also be irreparably harmed in the absence of a stay, whether by the business and financial effects of the loss or suspended employees' compliance and monitoring costs associated with the mandate, the diversion of resources necessitated by the mandate, or by OSHA's plan to impose stiff financial penalties on companies that refuse to punish or task unwilling employees. The mandate places an immediate and irreversible imprint on all covered employers in America, and complying with the regulation later held invalid almost always produces the irreparable harm of non-coverable compliance costs. The state, too, has an interest in seeing their constitutionality reserved police power over public health policies defended from federal overreach. The Constitution vests a limited legislative power in Congress. For more than a century, Congress has routinely used this power to delegate policymaking specifics and technical details to executive agencies charged with effectuating policy principle Congress lays down. For these reasons, the petitioner's motion for a stay pending review is granted. Enforcement of the Occupational Safety and Health Administration's COVID-19 vaccination and testing emergency temporary standard remains stayed pending adequate judicial review of the petitioner's underlying motions for a permanent injunction. So that was the video. So I think this was a major victory. Of course, there's a good chance this might go all the way to the Supreme Court if the Biden administration wishes to continue challenging it. Although I don't really see what the point is, but then of course the federal government has unlimited resources. They can do it without even thinking, and it really won't matter too much. No matter how much the bill is, they'll just keep taxing us to death and running up another debt and or deficit. So that's the video. Let me know what you think in the comment section below. Again, don't forget to share this great news with anyone you know who is under the pressure of forced jabs. Don't forget to subscribe to this channel, like this video, comment on this video. This is Bruce the Boss, and I'm out. Peace.